Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to talk to you about my list of the top 8 ways you can improve your chances of getting approved for Social Security disability. And this is not an exclusive list. This is not something that comes from Social Security. This is just reflective of my own experience in getting people approved for disability cases over the last 20-something years. So here's my top 8 list. First and foremost is you've got to have medical treatment, ideally without any gaps in treatment. In this current climate, I'm recording this in 2017, disability judges expect to see a comprehensive, unbroken medical record. You cannot have gaps of 8 months, a year, 18 months, 2 years, where you have not gone to the doctor. Even if you have a condition that is permanent and chronic, judges expect to see you go to the doctor. So a strong, consistent medical record without any gaps is really, really important. Number 2, your medical condition should be based on a firm diagnosis. It's very difficult to win disability benefits when your medical condition is sort of this wishy-washy, lot of different types of things. It's much better to be a firm diagnosis. You have spinal stenosis, you have chronic venous insufficiency, you have pulmonary function disease. It's much better to have a label on your condition than to have a number of various conditions that no one really knows what it is. That, by the way, is why conditions like fibromyalgia and CRPS are difficult to win, because they're sort of diagnoses of last resorts. And judges are much more comfortable awarding benefits on firm diagnoses where there are objective tests for those diagnoses. For a spinal stenosis, they can do an MRI. For chronic venous insufficiency, an ultrasound. For certain other conditions, nerve conduction studies, or EMGs, or CT scans. So anything that's subject to some sort of objective medical test, that's going to help. Obviously, mental health conditions don't fit that bill, but there are certain tests that psychologists and psychiatrists can do to make a diagnosis about a particular mental health condition like schizophrenia, depression, anxiety, and so forth. So the more specific the diagnosis, I think the better. Number 3 is always take your medications as prescribed and adhere to what your doctor tells you. It's not good when a medical record says that my client has not been compliant with medical treatment or my client's not taking medications. The judge will assume that you are not being compliant or you're not taking medications because you really weren't that bad off. So they expect you, judges expect you to be fully compliant with your medical condition. And if you're having bad side effects, for example, with medications, let your doctor know. Don't simply stop taking the medication, never tell the doctor about the side effect. We need to have a medical record that reflects all that type of thing, and it's really important that you do that. Number 4 is we need to have your medical information, your medical condition translated into work capacity limitations, which is the language Social Security speaks. That means you need to get your doctor to fill out a functional capacity evaluation or to complete a narrative report that addresses your limitations that arise from your medical condition in terms of how they would impact you at a potential job. That is the language Social Security speaks and that they understand. Work capacity. So you need a doctor who will cooperate with you in that regard. If you don't have a doctor who will cooperate, you need to find another doctor, because that's the language Social Security wants to hear. Number 5 is, before your hearing, practice. One of the things that I do with my clients is we spend probably I'd say twice as much time, 3 times as much time as the hearing is going to take practicing. I'll go over questions. We'll practice answers. This is the best way to answer. This is the most compelling way to do it. It could take 3 or 4 hours. But the important thing is when my client goes in to a hearing and a judge asks a question, that's not the first time my client's heard that question. You don't want to be in a situation where the judge says, well, how much can you lift? And you say, well, I never thought about that. I don't know. Not very much. Well, that's not good. You need to be able to say, I can lift 7 to 10 pounds once or twice during the course of a day, and I have to rest for 15 minutes thereafter. Or if I lift more than 7 or 8 pounds, a gallon of milk, I'll be in bed for the rest of the day because of pain. Or I can lift it once, but half the time I'll drop it. Whatever it is, you need to have an answer prepared so that you can answer credibly and believably about your physical limitations. Next is, I would tell you not to go into your disability hearing alone. People sometimes say, well, do I really need an attorney if my record's really strong? Here's the problem, is that judges are overworked. They go really fast. These hearings last about 45 minutes. They use a lot of acronyms, AOD, DLI, DOT, the list goes on, FCE, RFC. These are all acronyms that is sort of a separate language that disability judges and attorneys speak. And you got 45 minutes in front of that judge. You don't want to waste a lot of time trying to understand what's going on. So one of the advantages of having an attorney is, number one, we will come up with a working theory of disability for your case. That can be meet a listing, grid rule, functional capacity. We'll develop the strongest argument. And here, a lot of times, I'll have a client with 3 or 4 different things or 5 or 6 different things. I'm going to focus on the ones that I think that are most valuable for Social Security purposes, which may be different than what my client thinks. So it's really important to have professional guidance as to making the most of that 45-minute hearing and not to try to educate yourself on the fly when you're actually at the hearing. You're going to frustrate the judge, and a frustrated judge is going to probably say no. So hearings, you want to be really organized. A pre-hearing brief is almost always very, very helpful. These are things that an attorney can do for you. Another thing which is really, really crucial is that once you request a hearing, which again could be a year or two before you actually go to your hearing, during that year and a half where you're waiting, you as the claimant or your attorney has the responsibility of getting up-to-date medical records. If you walk into a hearing and the last medical record is 2 years before and you say, well, yeah, I've been to the doctor a bunch of times, but those records aren't there, you got a problem. Judge is going to probably deny the claim. Under some new rules that are going to go into effect in March of 2017, the record is going to close at the hearing. So you don't want to have anything missing. And one of the things that an attorney is going to do is to make sure that medical record is updated. So I would tell you not to go in. I think it's number 6, don't go in alone. Number 7 is you want to avoid even the whiff, the suggestion that you are malingering or drug seeking. Judges hate people who use the medical services to feed a drug addiction, whether it's prescription or not. So if you go to see a pain doctor, for example, don't go to see another pain doctor and get pain medications for both those people. Judges will assume you're selling the medications. That will destroy your credibility, and it's more likely than not you're going to lose your claim. So don't have any evidence of drug-seeking behavior, and in fact, you want to tell your doctor, I don't want to be on these narcotic drugs, and let's find some other way to treat my pain. Judges appreciate people who are trying to avoid these strong narcotic drugs that are out there nowadays. And last, I think number 8 would be, and I think this is really important, this is something I emphasize to my clients a lot, do not go in with the attitude of entitlement. We have to prove you're disabled. You can't go in and say, Judge, I know I'm disabled, please pay me. Judges pick up on that. They don't like people who feel that they are disabled already. You want to go with the idea, I'm a fighter, I hate the idea of being disabled, I don't want to be disabled, I'd like to go back to work, and I'm using this process only to get whatever benefits I can, financial and Medicare, so that I can get better and go back to work. My goal is not to be on disability the rest of my life. My goal is to get back to work. And if a judge senses that's what you're all about, not that you don't want to be on disability and take an early retirement for the rest of your life because you're disabled, that's going to go a long way to sort of subconsciously help the judge give you the benefit of the doubt and approve your claim. So those are my top 8 factors that I think are really important when it comes to trying to win a disability case. You may have some other ones. I'd be interested to hear that. Any attorneys watching this, if you have any other suggestions, please let me know that as well. We can certainly update this video at some time in the future. If you found this video useful, please give it a thumbs up on YouTube, like it on Facebook, subscribe to my YouTube channel, like my Facebook page, and if I can answer any questions for you, please reach out to me directly. This is Jonathan Ginsberg, wishing you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the Survival Kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include, how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know, how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.